There are people in this world who will push you and push you and push you until the day they discover that pushing you was the worst decision they ever made. I had been patient with my HOA for 2 years. 2 years of letters, 2 years of meetings, 2 years of watching them systematically target my property with violations that had no basis in their own rules while leaving identical situations on neighboring properties completely untouched. 2 years of being treated like a problem to be managed rather than a homeowner with rights. And then the threats started. Not suggestions. Not requests. Threats. Written, formal, and deliberate. And that was the day I installed an electric fence around my entire property, documented every single moment of what followed, and walked into a courtroom 14 months later with a case so comprehensive and so carefully built that the HOA's own attorney told my attorney privately that he had never seen anything quite like it. I had not just defended myself. I had dismantled them. If this story speaks to something in you, if you have ever been pushed by someone who assumed you had no way to push back, please take a moment right now to like this video and share it with someone who needs to hear it. Leave us a comment telling us where in the world you are watching from, because this community spans every corner of the globe and your location matters to us more than you know. Subscribe to Karen's Stories Daily if you have not already, because every story on this channel is about real people who refuse to be diminished by institutions that forgot they were dealing with human beings. This channel exists for you and for every person who has ever sat across from someone with a little bit of authority and thought quietly to themselves that they were not going to accept this. Now let me take you back to the very beginning, because this story did not start with a fence and it did not start with a courtroom. It started with a garden. My name is Cornelius and I had lived in my home for 11 years before any of this happened. I was not a confrontational person by nature. I was a quiet man who worked long hours in a technical field, came home to my property, and spent my weekends doing the thing that brought me more peace than almost anything else in my life. I gardened. Not casually, not as a hobby in the loose sense of the word, but seriously and with genuine dedication. My property reflected 11 years of careful cultivation. Native plants, structured beds, a small orchard in the back section, a greenhouse I had built myself over several weekends 3 years after moving in, and along the entire perimeter of my property a mature hedge that I had planted from small specimens and tended into something that was by any measure a beautiful and well-maintained feature of the landscape. The HOA had never been particularly warm toward me, but for the first several years of my residence they had left me largely alone. My property was immaculate. My dues were paid on time. I attended the occasional community meeting and otherwise kept to myself in the way that people who are genuinely content with their home life tend to do. There were minor interactions over the years, small disputes about nothing significant that resolved themselves without drama. I had no reason to believe that what was coming was coming. The trouble began when a new enforcement committee was formed within the HOA under the leadership of a man named Prescott, who had moved into the neighborhood 18 months earlier and had immediately become the most energetic and most ambitious member of the board. Prescott was the kind of man who needed to be important and who had found in the HOA enforcement role the perfect vehicle for that need. He reorganized the committee, increased inspection frequency, created new documentation procedures, and began conducting what he called comprehensive compliance reviews of every property in the neighborhood. When Prescott's compliance review reached my property, it produced a list of violations that I read with the specific confusion of someone encountering a document that does not correspond to any reality they recognize. The violations included claims that my hedge exceeded the maximum permitted height, that my greenhouse was an unapproved structure, that my garden beds in the front yard violated aesthetic guidelines, and that the overall character of my landscaping was inconsistent with neighborhood standards. Each violation came with a fine schedule and a deadline for remediation. I walked my entire property after reading that list. I measured the hedge with a tape measure. I pulled out the original HOA guidelines and read every relevant section carefully. And what I found was what I had suspected. Several of the violations were simply factually incorrect. My hedge was within the permitted height. The greenhouse had been approved under a prior board's review process with documentation I had kept in my files. The garden bed guidelines Prescott was citing had been amended 2 years before his arrival, and the version he was applying was no longer in effect. I compiled a formal written response addressing each violation specifically with measurements, photographs, dated documentation, and references to the correct current guidelines. I sent it to the board with a request that the violations be formally withdrawn. The response I received was dismissive. A brief letter stating that the committee had reviewed my submission and maintained its findings. I requested a formal hearing. The hearing was granted and I attended it prepared with every document I had compiled. I presented my case clearly and specifically. The board listened and then voted to uphold the violations with one exception, acknowledging that the greenhouse approval documentation was valid. Everything else was maintained. I appealed the decision in writing. The appeal was denied. I hired an attorney at that point. Not because I wanted to escalate, but because I had exhausted every internal process available to me and had received responses that were inconsistent with their own documentation. My attorney sent a formal letter to the HOA outlining the specific inaccuracies in the violation findings and requesting a resolution meeting. The HOA's attorney responded that the board was confident in its findings and that if I did not remediate the violations by the stated deadline, the fines would begin accruing. And then something happened that changed the entire character of the situation. My attorney, in the process of reviewing the HOA's enforcement records, discovered something that I had not known and that the HOA had certainly not volunteered. The enforcement actions against my property were not being applied consistently. 3 other properties in the neighborhood had hedges of comparable or greater height than mine with no violation notices. 2 properties had unapproved structures that had been flagged in internal inspections but never formally cited. And the aesthetic guideline Prescott had applied to my garden beds had not been applied to any other front yard in the neighborhood despite multiple properties having comparable or more elaborate landscaping features. This was not a compliance review. This was selective enforcement. And selective enforcement of HOA rules is not simply unfair. It is legally actionable. My attorney advised me to begin documenting everything from that point forward with the thoroughness and consistency of someone who knows they are building a legal record. I followed that advice with the same dedication I brought to my garden. Every piece of HOA correspondence was filed with date stamps. Every communication from my attorney was copied and preserved. I photographed every property in the neighborhood with comparable features to mine and documented the absence of violation notices through a systematic review of HOA records that my attorney obtained through a formal records request. And then the threats arrived. Not the formal violation notices and fine schedules of the earlier communications. These were different in tone and in character. A letter from Prescott on HOA letterhead stating that if I did not bring my property into compliance immediately, the HOA would seek to place a lien on my home. Another letter suggesting that my continued non-compliance was affecting property values in the neighborhood and that the board was considering what further legal remedies might be available. A third letter that my attorney described as the most aggressive piece of HOA correspondence he had seen in 15 years of practice, implying that my resistance to the enforcement process was itself a violation of community standards. I read each of these letters carefully. I gave each one to my attorney. And then I made a decision that I had been thinking about for several weeks. I was going to install an electric fence around my property. Not because I needed physical protection. Not because anyone had threatened me personally. But because I had researched the HOA guidelines exhaustively and had discovered that electric fences, while not mentioned positively in the community standards, were also not specifically prohibited anywhere in the governing documents. The guidelines addressed fence height, fence materials for certain types of fencing, and fence placement relative to property lines. They said nothing about electric fences as a category of installation. I hired a licensed contractor. I pulled every permit the city required. I had the fence installed professionally along the full perimeter of my property, properly signed with standard electric fence warning notices as required by local safety codes, and completely within every specification the city's electrical and fencing codes required. The installation was documented with photographs and the contractor provided a full compliance certification. I notified the HOA in writing that I had installed a permitted electric fence on my property and provided them with the contractor certification and permit documentation. I mentioned, helpfully, that I had reviewed their governing documents carefully and found no prohibition on electric fences and that I would be happy to discuss the matter if they believed otherwise. The response from Prescott arrived within 3 days. It was exactly what I had expected and exactly what I had been hoping for. The HOA issued a new violation notice claiming that the electric fence was an unapproved installation inconsistent with neighborhood aesthetics and demanding its immediate removal. The notice cited the General Aesthetic Standards Clause in the Community Guidelines, a broad provision that gave the board discretion to address features they deemed inconsistent with community character. This was the moment I had been building toward for months. Because the Aesthetic Standards Clause, read carefully and completely, required that the board apply it consistently across all properties. It could not be used selectively against one homeowner while similar or comparable features on other properties were ignored. And my attorney now had a comprehensive documented record showing exactly how selectively the board had been applying every provision of their own guidelines to my property compared to every other property in the neighborhood. We filed suit. The complaint was extensive and addressed every element of what had occurred over the preceding months. Selective enforcement of community guidelines. Violation of the HOA's own procedural requirements for compliance reviews. The factually incorrect original violation findings. The escalating threat letters and their legal implications. And the new electric fence violation, which we presented as the most recent and most clearly documented example of a pattern of targeted and inconsistent enforcement against a single homeowner. The discovery process that followed was illuminating in ways that went beyond even what my attorney had anticipated. The HOA's internal communications, obtained through the formal discovery process, revealed discussions between Prescott and other board members that showed an awareness that the enforcement actions against my property were being applied differently than enforcement actions against other properties. There were emails in which Prescott acknowledged that comparable situations existed elsewhere in the neighborhood but directed the committee to focus on my property specifically. The reasons given in those internal communications were not legal or procedural. They were personal. Prescott had taken a dislike to my garden's aesthetic character and had used the enforcement committee as a vehicle for acting on that personal preference. That evidence transformed the case from a dispute about HOA guidelines into something considerably more serious. It demonstrated bad faith. It demonstrated that the enforcement process had been weaponized against a specific homeowner for personal reasons rather than applied in good faith for legitimate community purposes. And it provided the foundation for damages that went beyond the cost of the legal proceedings themselves. The trial lasted 4 days. My attorney presented the full documented record systematically and completely. The photographs of comparable properties with no violation notices. The record's requests showing the absence of enforcement action against similar features elsewhere in the neighborhood. The internal HOA communications showing Prescott's personal motivations. The threat letters and their legal implications. And the electric fence installation, fully permitted, fully compliant with city codes, and cited as a violation under a provision that had never been applied to any comparable installation anywhere in the neighborhood. Prescott testified. Under cross-examination, my attorney walked him through every internal email, every directive to the enforcement committee, every communication showing awareness of the inconsistency in how my property was being treated compared to others. Prescott's answers became progressively less confident as the examination continued. By the end of his testimony, the picture that had emerged was not of a diligent community standards enforcer but of a man who had used an institutional position to pursue a personal grievance against a neighbor whose garden he did not like. The judgment came 3 weeks after the trial concluded. The court found in my favor on every substantive count. The selective enforcement findings were upheld. The threat letters were found to constitute improper use of the HOA's authority. The original violation findings that had been factually incorrect were addressed in the damages calculation. And the electric fence violation, the one Prescott had issued so confidently 3 days after my installation notice, was found to be the most clearly documented example of the pattern the court had identified, a provision applied to my property that had never been applied to any comparable situation anywhere else in the neighborhood. The total judgment included remediation of all fines that had accrued, full coverage of my legal costs which had been substantial given the length and complexity of the proceedings, and additional damages that the court calculated based on the documented bad faith conduct, including the internal communications showing personal motivation behind the enforcement actions. Prescott was removed from the enforcement committee by the board before the judgment was even announced, a decision that came too late to affect the outcome but that suggested even his colleagues had recognized by the end of the trial what the evidence had shown. The HOA underwent a comprehensive governance review in the months following the judgment. New procedures were implemented requiring that any enforcement action be cross-referenced against the full neighborhood compliance record before a violation could be issued, ensuring that no provision could be applied to one property without being applied consistently to all properties showing comparable situations. An independent oversight committee was established to review enforcement decisions before they were finalized. And the board adopted a formal policy prohibiting the use of aesthetic standards provisions without documented evidence of inconsistency with established neighborhood character as demonstrated across multiple properties. My hedge is still exactly the height it was when this all began. My greenhouse stands exactly where I built it. My garden beds, which I have continued to cultivate and expand through everything that happened, are more elaborate now than they have ever been. And around the full perimeter of my property, properly signed and fully permitted, the electric fence remains exactly where the contractor installed it. I did not remove it after the judgment. I had no legal obligation to remove it and no personal inclination to do so. It was installed legally, it serves its purpose as a clear boundary marker, and it stands as a quiet and permanent reminder of a principle that I think is worth preserving in visible form. The principle that when you do things the right way, when you document everything, when you understand your rights and you exercise them with patience and precision, no institution and no individual within that institution can ultimately prevail against you. Prescott had looked at my garden and decided he did not like it. He had used the power available to him to express that preference in the form of violations, fines, and threats. What he had not considered, what he had never apparently thought to ask, was what kind of person he was dealing with. Whether the homeowner on the other side of his enforcement committee might be someone who documented everything, who understood the legal framework, who had the patience to build a case over months and the resources to see it through a courtroom. He found out. And the electric fence on my property boundary, standing exactly where I installed it on the day I decided enough was enough, is the most concise possible answer to every threat letter he ever sent me. I still garden every weekend. The orchard is producing better than it ever has. The greenhouse is full this season with varieties I started from seed in January. And in the evenings when the light is right I sometimes walk the perimeter of my property along the fence line and feel something that I can only describe as a deep and uncomplicated satisfaction. Not at what happened to Prescott or to the HOA. Simply at the fact that patience and documentation and a careful reading of the rules turned out to be exactly enough. They threatened me in writing. I responded in court. And the difference between those two things, between what they thought they had and what I actually had, was 14 months of careful and consistent record-keeping and the absolute certainty that when you are right, completely and documentably right, the truth will find its way to the surface eventually no matter how much pressure is applied to keep it down. If this story moved something in you today, if it stirred something about fairness and patience and the quiet power of knowing your rights and holding on to them no matter what, please like this video right now and share it with someone in your life who is going through something similar. This channel exists because of people like you who believe these stories deserve to be told and who take the time to pass them on to someone who needs to hear them. Before you go, I want to ask you something simple. Leave one sentence in the comments below. Just one sentence describing a moment in your own life when you refused to back down from something that was rightfully yours. One sentence. Because your story matters too and I want to read it. Subscribe to Karen's Stories Daily if you have not already, and thank you from the bottom of my heart for watching until the very end. Stories like this one only reach the people who need them because of viewers like you who stay until the last word and then share what they found.